now for a bit of a different pace. We're going to engage in this first panel session on the legal, economic and policy considerations of catastrophic injury, and we've certainly got a good panel to be able to take some questions and engage in some comment on that. So I'll introduce our panel first, and we've got Professor Luke Connelly, who's a Professor of Economics in the Health and Behavioural Sciences faculty at the University of Queensland. Dr. Ros Harrington, you might have heard address just before lunch, a Senior Research Fellow at Griffith University, and Dr. Kylie Burns, a Senior Lecturer in Tort Law at Griffith University. So in 25 words or less, can you just please tell, so this saves me doing this job, can you please tell our audience just what your key research interest is currently or recently in related to our topic? So Kylie, perhaps.
Hi, thank you. Thanks for having me here. I think I might be the aberrant lawyer in the room, so I'm feeling a bit alien today, but I'll do my best to blend in nicely. My main research interest is in negligence law, so the common law framework by which people get compensation. And my work centres around looking at both how the law itself works, but also generally how it impacts claimants and society more broadly. And I'm also very interested in how the judicial system uses outside knowledge, so knowledge from outside itself to inform the law. I have also looked particularly at how the experiences of women play out inside the compensation system, and how tort law and also systems of rules dealing with compensation treat the injuries often suffered by women. And I'm very happily doing some work with Ros at the moment on lump sum dissipation and the problems in relation to that. So I might therefore pass to Ros.
Thanks, Kylie.
Okay, so really my key area of research interest is acquired brain injury and how we improve our responses to people with acquired brain injury, and that's come both from professional and personal experiences as well as a researcher. So my interest in injury and insurance scheme design really came about through my growing awareness of how injury insurance schemes promote the capacity of the service sector and influence and impact on people with brain injury and the types of services and supports they can access. So they've been my key areas of research. I've also done a little bit of research with Michele around how to respond to the lifetime care and support needs of people with acquired disability and high care needs. So that's people with acquired disability not just from injury but from other causes such as neurological impairment. And that really is closely related to the NDIS and the NIS, so I'm interested in both of those, both the NDIS and the proposed National Injury Insurance Scheme.
Okay, thanks, Ros. And Luke.
Thanks. I'm an economist, work mostly on health sector related problems, and mostly got interested in the health sector because there are so many sources of potential sources of market failure in the health sector. So all of the things that we set up markets to do and work perfectly, often the preconditions that are required for that fail in the health sector. So that was one of the reasons I got interested in health to start with. But I also work in insurance economics as well, and of course these injury compensation schemes are essentially big insurance schemes, although people don't often talk about them as if they are. And so most recently, I guess, in relation to this general topic, I've done some work as well on a thesis that's been that's found a fair bit of support in the medical community, which is to the effect that people who receive compensation have worse health outcomes than people who don't receive any compensation for their injuries. And so we've done a fair bit of work on that to try and find out whether or not there is actually a causal link. And our argument is effectively there are so many problems with trying to draw that connection that it's very difficult to do so on the basis of current evidence. So we think there are selection problems and a whole lot of other problems with trying to do that from existing observational studies.
It's good, and we're going to pick up on some of that too, Luke, a bit later. So how this, so welcome everyone and thank you for being here with us. So how this will run is I have a series of questions to pose, so it's not quite Tony Jones, bit of Jenny Brocky, and I'm going to ask each of our panel members to comment and invite the other panel members to comment. And I've warned a couple of them. If they get boring, I'm going to throw it open to you to start asking questions. So just as an opener in a general way, taking in mind your areas of expertise and your interests, what do you think are the priority legal, policy and economic issues today in Queensland for catastrophic injury?
I guess I can start. I think for me, one of the biggest issues is the fragmentation for recovery for people with catastrophic injury, and across Australia that really depends on how the injury happened and where the injury happened. And I know we've seen in some of the previous presentations some of the maps of Australia with the different motor vehicle schemes. If we then superimposed over that what it looks like for medical injury, for injuries that happen in other ways, we'd see an even larger fragmentation. And this is something that the Productivity Commission really identified in its report, that there are some people who receive catastrophic injury who might have a relatively good chance of obtaining some form of compensation, and typically those people would be in workers' compensation schemes. And there would be people at the other end of the spectrum who would have very little chance of obtaining currently any form of significant compensation. And probably people in that category would tend to come from things like an intentionally caused criminal injury, for example, where they couldn't get back from the perpetrator, there wasn't an insurance scheme, and their only access was to some very small amount of criminal compensation. So I think that's a very big issue that needs to be addressed, and I know that's in the sort of initial discussions of the NIST that was something that was very much focused on, that there's a great inequity in addressing people who have the same need in entirely different ways depending on where they are in Australia and how they happen to become injured.
Yep. Ros?
Yep. Okay, well, just following on from that, I'd say the number one policy issue is obviously the proposed National Injury Insurance Scheme from my perspective. But I think particularly for Queensland, we really do need, and this is where Luke's work will probably come into play, we really do need to have some understanding of the long-term impact of catastrophic injury and what that really costs, not just in terms of access to inpatient rehabilitation services and that end of the spectrum, but the whole spectrum of people's lives, and not just the impact on the individual, but also the impact on families, not just a spouse or a parent, also siblings, and how we can reduce those impacts. I think if we could get some really good economic costing around those costs when you don't provide rehabilitation, comprehensive rehabilitation to people, as opposed to what they would be like if we did provide comprehensive rehabilitation, then we might have some really strong groundwork to look at whether this is feasible.
Yep, well, I'm certainly going to be asking Luke some questions around that topic, but for now, Luke, what do you see as the priority?
Look, I think it's obviously about the competing interests of the competing people who might compete for funds and packages of care under the NIS, and so I think there are some big picture questions about definitions of catastrophic injury, where they extend to, and also at the margin when you start to provide some people with more and others with less, how are you actually affecting health outcomes or well-being at those margins? And beyond that, it's obviously about expenditure, which is the quantities and the prices of the services that you're going to worry about, and both of those variables are also of concern.
Okay. Thank you. Oh, gosh. Okay, so I'll follow up firstly then, Luke, on the question of costs of catastrophic injury, and I know you've done work in this. So what do we know about the direct and indirect costs of catastrophic injury currently? And we got a national picture of that? Have we got a state picture of that? And what are the complexities around that?
I think we do have some measures of those. The measures that we have typically come from commissioned reports on the economic burden of an illness or a disease, and often they're commissioned by bodies that are interested in a particular advocacy area. They often involve a lot of double counting of costs in categories that are variously financial and non-financial costs, so that those costs matter in different ways to different segments of the community, including government. So there are some things that are quite frightening that we don't know, or that we think we don't know, but we should, including, to use an NDIS example, the case in South Australia recently where provision was made for 5,085 kids with autism aged 0 to 14 to be included under the the trial in that state, only to find that actually there's 11,000 people who would be eligible for these services, or somewhere approaching 11,000. So, you can ask, well, how did we not, in terms of thinking about the quantities and the prices of the services that people might need or be entitled to, how did we not know that there was that number? And the answer is we actually do know. With the Australian Bureau of Statistics collects data on unmet need for disability. Their most recent estimates suggest that there's about 1.5 million people in Australia who have a need for formal care with a disability, and just over 50%, so it's 774,500 people, have an unmet need, meaning either they don't get any services or they get services but they're inadequate for their needs. So this question of what the latent demand might be in the case of disability services, but also in the context of injury, how much of that picture are we not actually seeing, and how then can we predict expenditures if we don't know even the numbers of people in different categories? I think we've probably got a better idea for injury than we have for disability, but I mean, one would think, this is part of the problem, of course, if you don't have services, you don't see a queue for those services, so you don't know whether you've got enough. Once you create the service, you actually then start to pick up the latent demand that exists for it.
Thank you. So there's a couple of things here already bubbling. It's about the uncertainties of need, the uncertainties of demand, and then policy questions also about, how much is adequate. Now, Ros, in your presentation earlier, you talked about particularly Queensland being an ad hoc, crisis-driven type of system, and you drew one of the key messages was about explicit entitlement. Can you say more about that? Because I imagine that's quite a murky issue all the same.
Yeah, look, I think just on the basis of my PhD research, when entitlements are explicitly laid down, like you have an explicit entitlement to lifetime care and support, then it facilitates access to those services. If there's no explicit entitlement, if it's a contestable system, as in Queensland, then people don't really know what services they could be entitled to access. So clear entitlements that clearly specify an entitlement to, say, attendant care support to access the community for participation. Those sort of entitlements are really important to be laid down so that people know what they can access to equipment, access to parenting support, for example, some of the things that came through in the TAC study. And those entitlements are explicitly outlined on the TAC website. So it's also about making information about entitlements accessible for people so that they can actually access those things. Not everyone will access entitlements. From my research in the TAC system, not everyone accessed all the entitlements that they were entitled to access. But without that clear system of entitlement, then you're going to have a lot of people who have unmet needs, basically. Does that answer your question?
It does, but I guess coming back to Luke's point, then the issue around having clear entitlements, it still has to be based on certain principles, doesn't it? And cost obviously is one. Entitlements may be specified in scope, but not in quantity, and that's, I guess, is an economic question.
Yeah, and I guess one of the questions is how much do we, what sort of criteria do we overlay on that? So some of this is a philosophical issue, but some of it's actually about what good can be done for which groups, and how much, if we allocate a certain quantum of resources to this group, we have to deprive some other group of that. So how do we actually try to do that in a way that actually optimises the benefits the system creates for everybody?
So typical policy questions of trying to reconcile often competing principles around equity and evidence-based and cost-beneficial. Yep. Okay, so Kylie, I'd like to bring you into the discussions. We know that compensation schemes have an objective about restoring claimants' well-being. We certainly know from the Productivity Commission's report they estimate around 50% of Australians with catastrophic injury are compensable under the existing accident and injury schemes. How well are we doing, do you think, in meeting that well-being objective?
I'm not particularly positive that we're meeting the well-being objective well. particularly in fault-based schemes. And I actually think there might be an underlying reason why that's so, and that's because from a lawyer's perspective, and I can only speak from a lawyer's perspective, the underlying goal of a compensation system, particularly a fault-based one for us, is actually not to restore well-being. If you said to most lawyers, what is the number one goal, what they would say to you, I suspect, is number one, to correct a wrongdoing. It's this idea that justice has to be served by holding someone accountable, and that's essentially what we see the system as doing. And the way in which we hold them accountable is that we deliver some compensation, and that may or may not impact the well-being of the client. And that is not to say that lawyers aren't concerned with their clients' well-being. It's just, I think, quite a different mindset about how you see the system as working. And so it's probably not surprising if that's how you set up a system, that you don't necessarily get well-being as an outcome of it. I should also say I'm not sure that it's actually delivering the other aspects very well either, because what we do know is very few people will say ultimately have a successful case in court, and I highly suspect, and maybe some of this comes out in Roz's research, even when people are actually successful in court, they don't tend to get that good feeling they thought they would about, oh, suddenly I feel so much better because I've been successful. So certainly within the legal discipline, when we talk about these things, no one's particularly rosy about compensation schemes delivering on many of their objectives, including the ones that lawyers think are most important.
Yeah. Luke, you want to?
Oh, well, let's go there. Just thought that this might be something Kylie might like to comment on as well, is that, you know, one of the things that we should also think about in relation to insurance schemes that indemnify people for harms they do is that you in fact remove incentives to not do harm. And so, you know, some of our insurance schemes do remove that individual responsibility to try to avoid doing harm.
I mean, it's true. I mean, another thing that I didn't mention is that economic legal theorists, for example, would say that we have the systems we do because they provide deterrence, they prevent accidents, and they send a signal out to the market. But what we know is that it's at best probably a really weak signal, and insurance is one of the reasons why it is weak. People are shielded from direct action. But I also think probably that when claimants go into a process and they take legal action, although they know that an insurer is involved, they're sort of seeking some sort of response from the individual person who wronged them. And typically the system doesn't deliver that to you. And one of the main reasons is practical, because the vast majority of cases settle, and they often settle without admission of liability and on a confidential basis. So it doesn't even deliver that person-to-person signal often. Sometimes it does, but not often. So people don't even get that feeling that someone has said to them, I'm very sorry that I did this to you, for example.
Yeah, I was just thinking about a conference that I went to where somebody spoke about how they felt once they got the compensation settlement, and they actually became quite depressed, because it was like, there's this figure, this is what I'm worth, this is what my injury's worth. And that was very disempowering for them. What was empowering for them was being able to access services that help them to rebuild their lives and re-engage in life roles. And the compensation seeking process doesn't necessarily do that. I think the research literature indicates that involvement of a lawyer may reinforce attributions of blame, which is, you know, that's the premise of common law, is that it's restitution for a wrongdoing. But we know that when people blame others, they generally have poor outcomes. So there's all of these overlays within the compensation system. The other thing is that sense of disempowerment and not having control over your own recovery when what's being provided to you is being dictated by an external body. So there's lots of things that can impact negatively on the individual. Previously, originally in a lot of the compensation research, the premise that people were seeking financial gain, and that's why they had poorer outcomes when they were compensable, was something that was frequently cited. But I think we're starting to understand that it's actually these processes that can be harmful for people after they're catastrophically injured and their families.
Well, let's pick up on that point, because Luke, I'm pretty sure you published a paper that concluded there was no quality evidence that suggested that the compensation was bad for health outcomes. Can you tell us a bit about that?
Yeah, so this is one of the things that's happened in the clinical literature. It's mostly health journals. People have used really a range of concepts and put them together and said we're going to look at what they're interested in is what economists would refer to as a latent factor. What the latent factor is involvement in a legal process, but the measures of that latent variable have been all sorts of things that have been basically treated as if they're homogenous. So did you have a lawyer is treated as being, equivalent to did you engage in litigation, did you go to court, did you, and a range of concepts that to legal scholars are just quite distinct. And furthermore, of course, you can't randomise in clinical work. We'd like to randomise people to a treatment or a non-treatment. So if you're trialing a new drug, you wouldn't just look at what happened to people who took the drug. You'd randomise people to take the drug and not to take the drug, and then see if there's a difference. And of course, it's usually infeasible to do that with a lot of social phenomena, and compensation and seeing lawyers is one of them. So we basically just showed that most of the literature is based entirely, in fact, on observational data like this, not trial data, and that has all sorts of attendant problems. So, people can say, well, we control for people's baseline health. Well, that's good to do that. I mean, it's good to do that if you can. But controlling for baseline health doesn't mean that two people with equal baseline health in 3 weeks' time will be doing equally well. So the person who goes to the lawyer may actually realise in a month's time that I'm not getting better. I better go and do something about this. But I better see, at least find out what my rights are. Our argument is that it's very difficult to disentangle and get a clear causal signal out of this correlation between these two variables. We showed with a couple of data sets that it's possible to do that, and when you do that, the apparent compensation effect goes away. So I'm not saying that our research indicates that there's no link between compensation systems or aspects of compensation systems and poorer health outcomes. There may well be, and it's certainly something that we should be concentrating on, because there is an inherent tension between appropriate restitution and what economists call moral hazard, people going for larger sums than they're really entitled to. But I think the effect is likely to be much smaller than what we see when we take appropriate measures to try and get rid of all these sources of bias. And the other question I think we still don't know the answer to is whether or not these processes cause short-term pain for people, but actually in the long run, once the case is settled and so on, are they actually better off? I mean, there are a lot of things that people go through in life that aren't pleasant. Their long-term well-being isn't actually badly affected by that. So I think that in clinical circles, for many people, this is regarded as being proven that people who get compensation have poorer health outcomes. And of course, if you're a surgeon who believes that and you're worried about your success rates, you might not want to even treat people who are being compensated. So I think it's a dangerous conclusion that someone's drawn.
Kylie, I'd like to bring you back in on that topic if you wanted to elaborate on that, but also bearing in mind where the status of the knowledge might be, how can we then at least improve these processes or perhaps minimise potentially adverse processes?
Well, first of all, I think that there is no doubt that if you have to go through a litigation or compensation recovery process, that it will be extraordinarily stressful. It's a risky process. It takes a lot of financial resources to go through that process, which many people won't have. It's risky because not only for the reasons Roz has raised, because you don't quite know what you're likely to get, but the risk is that even if you don't have to meet your own legal expenses because you're in a no-win, no-fee, if you lose, then you could be paying hundreds of thousands of dollars in somebody else's legal expenses, that is, to the defendant, whoever that person is. So you can be left in a position, and I certainly teach these cases all the time when I'm teaching students about cases that have gone to court, where some people might have a catastrophic injury, litigate sometimes all the way to the High Court of Australia, which would involve hundreds of thousands of dollars of costs, and be the ultimate loser. So be left with a catastrophic injury, no recovery, plus hundreds of thousands of dollars of somebody else's legal costs. So that process obviously involves a great deal of risk and stress, and those things I think are probably minimised if you're not going through if you settle earlier, if you're not going through a common law system, if you're going through some form of no fault, more supportive system of the kind Ros was speaking about this morning, without even looking at the evidence, I'm going to make a common sense assumption, and lawyers are really fond of those, that that is likely to be a much better outcome than having to litigate through a risky system. Now, that's not to say there aren't winners through the common law system, and that is why lawyers are quite fond of it, because if you are ultimately successful, that is the way you will maximise your amount of damages. You will no doubt get more through that if you are one of the people who are successful, but we refer to that as a litigation lottery, that if you're that person, then you're a lucky person, not a typical person. So there is no doubt, I think, that having a much more supportive, no-fault option with early intervention, early support being pumped into people, and shortening the time span that it takes for people to go through the system. So there are cases going through the High Court with catastrophic type injuries where people were injured, say, 15 years ago, and they're still waiting for compensation. So anything, I think, that shortens the time span as well is likely, or even if you have to wait for your common law damages that long, provides support in other ways much earlier, I think is likely to be a better system.
Thank you. All right, if we fix the legal system, let's go back and look at it a bit more broadly now. Ros, I'd like to pick up again on some of your research focus and interests. If we think about the needs of people with catastrophic injury, and clearly we all know they commonly cut across a range of policy areas of health and disability, housing, employment, and so forth. And we've heard a lot about how fragmented these systems are. You know, what are our options for taking whole of government approaches to catastrophic injury?
Look, I think there's a number of options. I think the spinal cord injuries response in Queensland, which is a whole of government initiative, is well recognised nationally and internationally as a really good whole of government response to a select group of people with catastrophic injury in our community. Unfortunately, people with brain injury can't access that initiative. I think that to deliver a coordinated, comprehensive, integrated response that spans across multiple policy areas and service contexts, you do need some sort of overarching structure that enables that process to happen. That's what the spinal cord injury response does. But under an insurance framework, if you have individualised funding and an overseeing body that's helping to ensure coordination across services, that also can provide that. The spinal cord injuries response does deliver individualised funding, so it has those key attributes of individualised funding as well as a systemic planned response to improve the pathways of people after injury. The difficulty is having the funding for those initiatives, and certainly the spinal cord injuries response got that funding. A group that I chair really lobbied quite actively for a similar response for people with severe traumatic brain injury in Queensland, and we didn't get it, possibly because the NIS was on the horizon, and the introduction of an MVA NIS in Queensland could create that overarching body that could integrate services across different sectors during somebody's rehabilitation pathway.
Well, let's put our eyes on the future then, and the prospect of the NDIS and the prospect of the NIS, as recommended in the Productivity Commission, the implementation of both those schemes, and the proposed funding mechanisms. Luke, we're suggesting there's some variation with the NIS, the NDIS saying being a pay-as-you-go type of scheme, and the proposal for a NIS would be a fully funded scheme. Can you tell us what the differences here are in terms of, well, essentially what they mean, but also what they mean in terms of the cost benefits or the approaches to lifetime care and support?
Yeah, so I mean, I guess one of the things that's interesting when you think about it, the NIS and the NDIS, is that we're thinking that way because we've got a current stock, a prevalence of people with disability. And so economists refer to that type of a concept as a stock. You've got a stock and then you've got a flow. The flow of the people being injured and becoming disabled, and the stock is what's currently there. So that's the reason we think about NDIS and NIS. Whereas in fact we're thinking about disability insurance schemes, and there's this bifurcation because we're trying to deal with people who are already disabled and need services, and then a flow of new people who are going to need those services too. So in that sense, that distinction makes some sense, because when you're talking about a prospective group of people, then you can think about insurance, because insurance is for conditions of uncertainty, and so that's why it makes more sense to think of that NIS component as the insurance scheme, whereas NDIS is of course an insurance scheme in the longer run too. I'm not sure if that answers your question, but that's partly the reason that you've got this differential in terms of the way that people are thinking about funding as well.
Any other comments from the panel?
Just unpack for me a little bit more the difference between a fully funded scheme, which is what the proposed MBA NIS would be, as opposed to a pay-as-you-go type scheme, which is what the proposal for the NDIS is, and why.
I could unpack it if I knew what those, precisely how those concepts have been defined. One of the problems that I find around the discussions of NDIS and NIS is that there's quite a bit of vague and nebulous talk and amorphous definitions, and that's one of the biggest dangers, I think, is that once you start to have definitions that are slippery around entitlements, around who's eligible and who's not, and about what the funding mechanisms actually mean, there may be people in the room who know much more about precisely what is meant and whether it's been written in stone yet. But no, I perceive the distinction as being one where, okay, if you've got a group of people with disabilities who need disability services there, and they're already in existence, you have to find a way to fund them, and you'll do that on an ongoing basis. Whereas the fully costed notion is more an insurance notion, where you say, look, we're going to have to try to estimate what we think the distribution of injuries and the costs of those injuries are going to be for the lifetimes of people who sustain them. And then we're going to have to come up with a way of funding that into the future that's not just a recurrent drain on the budget. It needs to be done as an insurance mechanism. So then you think about, having a levy for motorists, or something on your phone bill, as we did for ambulance services in Queensland a while back. So that's what I think people are talking about conceptually with that distinction, but what they mean in practice is quite distinct.
All right, I'm going to reward you now because you've been so eloquent in your answers. We've got a few minutes to take some impromptu questions from our audience. So would anybody like to? Yes, Bronwyn.
Bronwyn Morecambe from the Young People in Nursing Homes Alliance, and this is a question to the panel generally, but I guess Ros particularly, given your research. We've heard today about the evident need for rehabilitation and catastrophic injury service responses. We're all clear about it, but the NIIS is sunk like a stone. It's nowhere to be found. It's not on people's radar at all. We've had Molly Meldrum falling off his ladder and sustaining a brain injury in a domestic accident. We've had Alex McKinnon in the NRL breaking his neck. What do we need to do to raise this to the level that the NDIS enjoyed, and how do we get there? We've got the research. How do we take it to the next level?
That's the million-dollar question. Look, I was having this discussion earlier today about change is slow. We know that. I mean, anybody who's worked in disability knows change is painfully slow. I think that if you look at the Productivity Commission's recommendations around the NIS, they were that the NIS would actually be launched before the NDIS. That made a lot of sense to me, because you were more likely to get the NIS implemented if it was implemented first than if you try to implement it on top of the NDIS. But their recommendation was that the first stage in implementing that reform was to align all the motor vehicle accident injury insurance schemes, so that each scheme would have its own catastrophic injury scheme. That scheme could then be expanded to cover other forms of injury over time. Now, that part of the NIS has gone ahead. Like when I started my PhD, there were only 4 states and territories that had no-fault insurance. Now, every other state, as of July next year, every other state and territory will have no-fault catastrophic injury insurance for people who are injured in motor vehicle accidents. So I think if that can get over the line in Queensland, well then I think that we've got the start of a NIS. We'll have it for motor vehicle accidents. I can see that expanding to cover other forms of injury. Inequity creates change. And one of the driving forces for me in my research was the inequity that the spinal cord injuries response created, and my experience in brain injury and knowing how difficult it was for people with brain injury. So I think introducing an MBA NIS would help to move that. I just hope that in Queensland we don't have to have what happened in Western Australia, which was that a young footballer got tragically and catastrophically injured in a blameless motor vehicle accident and ended up in residential aged care, and that's what got the whole state behind this reform. I hope that we don't have to have that sort of event in Queensland to actually have an MBA NIS implemented in the state.
Okay, time for another quick question and response.
Jen?
Yes,
Can I ask a
Emily?
question?
Yes.
I'd like to ask about market failures, which you mentioned, Luke, and also Ros. I guess thinking about some of the, I don't think we're hearing the NDIS talking about market failures yet, surprisingly, but just some examples. So I think several years ago in the UK they issued vouchers for several things that they hadn't in the past, like wheelchairs, and they found that the price that they set it at, you couldn't get anything for less than twice that price in the market. Likewise, we want to give people choice and control, and Ros, you gave some examples of how people do need some agency for their well-being, but at the same time, in some of the systems where there were bounded choices, you're perhaps less likely to run out of all the money at once. What happens? Have you heard anything from the agency about how they're anticipating they'll deal with this, and do you have any comments or recommendations?
Luke, did you want to ask?
Yeah, sure. I mean, yeah, good question. So one of the things, although I'm interested in market failure, there's also government failure, right? So we're going to see a bit of that as well, I think, and we're already seeing some of that. But I think the issue that you're talking about in relation to when you introduce subsidies or vouchers or whatever, there's a further issue, which is one of the sources of market failure is market power. And when you try to ramp up a new scheme like this one quickly, when we worry about taxes, if you think about the standard discussion of taxes, when cigarette tax goes up, people say now this will all fall on the consumers. In relation to cigarettes, that's pretty close to being true. The manufacturers will take some of the hit, but most of it will get passed on to consumers, because the demand for those services is quite price unresponsive. But when you get a situation where the supply is quite price unresponsive, then you have a similar problem that when you provide a subsidy, that in an industry where supply is already at capacity or close to it and can't expand quickly enough, what happens is that largely the subsidies end up in the pockets of the suppliers, not the consumers. And so you have this sort of case where you have, yes, now you can pay less out of pocket for a wheelchair, but all of a sudden, you're paying close enough to maybe the out-of-pocket price might approach what the previous market price was because of this short-term supply constraint. And so this is one of the issues around, I was saying earlier, you need to worry about quantities and prices. When you worry about prices, the short-term risk for both the NIS and NDIS is that you have a limited number of suppliers. You have on the demand side at least the competition and individual control, which should help with some of that. But you do have companies that have got a fair bit of market power in the supply of these services, and they're likely to pocket a substantial part of the subsidy if these schemes are rolled out quickly and in a big bang way. So in some respects, the slower rollout and the sentinel sites and study sites for NDIS and so on, although they're not desirable for the people who have to wait, they do actually prepare the market a little bit better for those services to be rolled out in a way that will benefit ultimately consumers more than it would if it was done overnight.
Thank you, Luke. And unfortunately, we'll have to draw that to a halt. And clearly, our panel has raised some very conceptual as well as practical applied implementation questions around policy, law and economics. And the issues they've raised are definitional, they're issues to do with allocation principles, entitlement and costs. And clearly all of these things are complicated for law, policy and economics because they have a context. And that context is complex, it's diverse, it's personal, and it requires a lot more detailed understanding. So I'd like you to thank our panel members for their insights.